All right, everyone, welcome. We're just letting everyone in, and we'll start in a few minutes. All right, everyone, it is 12 o'clock, and here we are. We're going to start with our mid-year employment law update as everyone sort of trickles in. We'll give everyone a few more minutes before we jump completely in, but excited to be doing this with all of you. All right, yeah. Okay, all right, let's get going. So, welcome. This is the mid-year employment law update. As you know, we do this a couple times a year when things change. You typically either at the end of the year, beginning of the year, or and sometimes here in the middle of the year because laws are changing. They're changing pretty frequently. Now, I know this is scheduled for 2 hours and which is a crazy long time to do it, especially on a Friday. But we are going to power through some stuff. It won't be the full 2 hours. I'm hoping to get through a lot of this in an hour, and I know many of you are on your lunch breaks. So we're going to power through a lot of this material because there has been a lot of changes nationally that we're going to talk about. And so just be aware of that. There is going to be some QR codes, towards the middle, and I'll bring that up to you as well. If you have any questions that pop up into your mind as we're going through this material, go ahead and put it in the chat box that is in the system. And then at the end, if we have time, I'll make sure to answer as many of them as we can. Okay. So I want to take a step back and really talk about the big picture for a moment, which is why is it so important for practices to care about HR compliance? And the reality and the truth is that managing HR compliance is getting more and more complex. And if there's one thing that we can absolutely count on beyond death and taxes, is that it's the rules are going to keep getting, are going to keep changing, and are going to keep getting more complex. I mean, that's really the reality of where we are. And then between shifting federal guidelines, evolving state laws, city-specific ordinances, which is happening more and more these days, the risk of falling out of compliance is real and it's growing. And so one of the reasons we do these kinds of seminars is so that you become aware of all these rule changes and can start taking action on making sure that you're compliant. So we're not talking about check the box, HR anymore. What your grandparents did in terms of HR doesn't apply anymore. This is all about legal exposure, financial penalties, and yes, even sometimes lawsuits. And so our goal is to minimize that or get it to as close to zero as possible. Now, when a lot of people think about the HR, they're thinking about hiring or keeping employees happy. And that's definitely part of what we're going to talk about. But real HR compliance, it's about safeguarding the business, right? Safeguarding the business. And I had actually a pretty funny situation. One of my daughters, my oldest one, is back home for the summer and she got this volunteer job and they actually are paying her. So I don't know exactly, you know, how this position kind of came about, but it's a volunteer position, but they're not volunteering, they're actually getting paid for it. And she had to sign into all of these documents that this business, this nonprofit had through one of the big payroll companies. And their platform, right, which quote unquote does HR, and we see that of course, had some of the basic documents, but it was missing really key documents that she needs for federal compliance, like the I-9. And so what I guess my point is that this is about safeguarding your business from A to Z. And there's a lot of different shortcuts that people think of, and there's companies that say they do certain things, but the reality is that they don't truly know your obligations. They don't truly know what you need because they're not specific to healthcare like HR for Health is. And so that's why we're doing what we're doing and why we are here today, answering these questions and going through this material. So please make sure if you do have questions, you don't forget about it. You put it in the chat box, and then we'll go from there. Now, in terms of knowing your obligations under the law and making sure you're protected, that's what today's goal is. Now, none of you are going to become HR experts by the time we're done today, but what you are going to get is a really good detailed analysis on all the law changes that are happening. Because the hard truth is that courts are not forgiving when it comes to ignorance and not knowing these rules. And so we want to educate you so you know them. You're not going to become experts, but you'll know when to ask for help. And that, I think, is the key, right? I think the key is knowing when to ask for help. And so that's what we're going to be talking about today. So let's jump into it. As most of you know, my name is Ali Oromchian. I'm the CEO and founder of HR for Health. I'm also a healthcare attorney, and this is what we do every day for doctors around the country, helping them with their transitions and partnerships and buying and selling of offices. And of course, HR compliance, helping you navigate all the difficult aspects of HR compliance. And so I'm excited to be doing this for you guys. And I'm also excited because this is my last webinar I do this summer before going on vacation tomorrow. So super excited about that too. All right, so we're going to talk about federal trends and changes. We're going to talk about some state level trends and changes that we're going to talk about, and then what do you do next? Okay, so let's start with what's happening at the federal level, because it feels like the ground keeps shifting under our feet when it comes to employment law. And the reality is that it is changing, right? The ground is moving because there's so many changes that are occurring. And right now, there are lots of proposals in motion in Washington. But here's the catch. In motion doesn't always mean forward motion. Okay, that's important. Sometimes things are speeding ahead, and sometimes it's full on going backtracking and going backwards. And if you're not nimble and if you're not paying attention to your practice, it's really easy to get caught off guard by all of these changes that are happening. And we're going to talk about some of those. So in this segment that we're going to have, this part of the presentation, we're going to break down the top federal employment law changes that we've seen so far in 2025, including the FLSA salary threshold, the battle over independent contractor classifications, and then also what's going on with the National Labor Relations Board, or it's called the NLRB, and we're going to unpack all of these in detail and talk about what's standing and what's staying as law, what's changed, and what do you need to actually do about it. And because we want you to be proactive now, as it's a lot easier than dealing with some of these penalties that may come down the line later. Okay, so let's talk about what's happening at the NLRB, right? The National Labor Relations Board, because there's a lot going on. There's a lot going on, and it's going to have a really big impact on
Oh,
employers and
one
employees.
second, Ollie.
Oh,
I just see a note in the chat that someone says they cannot hear you. Is there anyone else who can't hear Ollie at the moment, or is this an individual issue? Just want to make sure everyone's able to, hear everything you're saying. I see a thumbs up.
yeah,
Okay,
it might be an
perfect.
individual.
Okay. Okay,
Okay,
Spencer, you might need to check your mic. Okay, thank you guys so much. Appreciate it.
thanks everyone for responding. Thanks, Jasmine. Okay, so there's a lot going on, right? There's a lot going on across the country. So let's talk about this. Here's the thing with the NLRB. It swings hard depending on who's in power. So under the Biden administration, the NLRB was very pro-labor, aggressively so, right? Aggressively so. But now, with this second Trump administration, we're already seeing a sharp pivot in the other direction. And chances are that this pendulum swing is just getting started, as we're only in month 6 of the administration. So, if you remember, a few months ago, the NLRB actually issued a memo that basically walked back several of the decisions that they had made under the Biden administration. Now, it didn't get a lot of press, so many of you may not have even seen it happen, but they did. Now, to be clear, these memos, which we're going to talk about in a second, are not law, right? They're not binding law, but they do matter, right? They do matter. And the reason they do is this shows us how the agency is thinking and how they're going to guide the local NLRB offices and what to focus on. Okay, so what are some of these updates that we're talking about? Well, first up, the one that's probably the most important for all of you is the non-compete agreements. Okay, if you remember, right, last year, actually the year before last, there was a lot of talk about the NLRB and under the Biden administration and whatnot, basically voiding all non-compete agreements, and they did. And then there was lawsuits around the country. So in both the NLRB and the FTC were cracking down hard on these non-competes. The FTC even issued a rule in April of 24 that would have pretty much banned all non-competes across the nation, And so when you think about that, what happened? Well, that's now out. The new administration rolled back that entire push. The message became super clear. Non-competes are back on the table, and they're going to be governed at the state level as they were before, at least until the courts rule in a different way. Okay, so for many of you who are employers who are worried about the non-compete, this is a very big development. For a lot of you doctor associates or employees who are hoping that the court cases would move forward rapidly, or that the Supreme Court will rule on them, it still can happen and whatnot, but it might be a little bit slower of a process, and they may never ever actually get ruled on if the Supreme Court doesn't accept the case. So that's that. Now let's move forward to another part of employment agreement that's really important, which is confidentiality and non-disparagement clauses in severance agreements. So you might remember that under the Biden administration, there was a huge push to limit these. Broad language that prevented workers from talking about their experiences or sharing concerns, especially non-management employees, right? That was a huge no-go, right? Like absolutely. Well, that's really no longer the current policy. And the memo that was issued says that the focus should not be on that anymore. But here's the underlying kind of part of it that's sort of a catch. The decision hasn't been overturned yet. So if you're still including these broad clauses, then you might still be at risk, but the likelihood is that at some point they're going to go away. Okay. So what we recommend is if you're going to have these, write down, drafts very narrowly written confidentiality clauses, the kind that just protects trade secrets and proprietary information for a limited amount of time. Okay, so and if you do that, then those are still considered okay. And as long as it's for valid business reasons, which for most of you it is, because you're protecting your patient list and your business practices and whatnot, then you should be okay. Okay, you should be okay. Now, one final thing is you guys have heard about all these cuts at the federal government level. Well, the NLRB is not fully staffed now. It still needs three more board members, and until those seats are filled, the current administration can't really officially change any of these laws or push anything. So, with as far as their agenda is concerned, so we're in a little bit of a holding pattern, right? We're in a little bit of a holding pattern, but we do see what the future looks like. We do see what's coming down the pipe through this memo and what's going to be paid attention to. So it's important for you, as an employer to know that. Okay. Now, one big change that has sort of flown under the radar for a lot of employers is this rule around salary thresholds for exempt employees. Okay, exempt employees. Now, these are employees that are exempt from overtime, exempt from lunches and breaks. So here's, to give you a little bit of history, here's sort of what happened back in 2024. The, the Department of Labor, okay, under the Biden administration, basically announced a rule that significantly raised the minimum salary requirement for an employee to be considered exempt from overtime, right? The new threshold was just under $59,000 a year. It was like 58,626, which is about $1,128 a week. And it started in January of this year, in 2025. Well, on top of that rule, there was some automatic increases, for every 3 years. Well, that didn't really stick, right? That didn't really stick because in November of 24, a federal judge struck all of that down. So, so now that increase is off the table, right? The salary threshold for exempt status stays at the old number of the 35,568, which is good. Now, the Biden era Department of Labor did file an appeal. The Trump administration's more recent filing back in April makes it pretty clear that this may not be a priority moving forward. So we may see a different rule at some point, but there's no update just yet. Now remember, this is at the national level. Each state might be different. It may have its own rules with regard to exempt and non-exempt. So you got to be very careful about this as well. Okay, we're talking about it more from a national level. Okay. So for you guys as an employer, if you already made these changes like bumping salaries or reclassifying employees because you were anticipating this threshold, you can keep those in place. But if but technically you're not necessarily legally required to, unless you've signed contracts and things of that nature. And I would recommend that you show it to an attorney or call our law firm or your own attorney and kind of walk through it. Okay. But remember, as I mentioned, this is at the federal level. Don't forget about state law, because some states like California and New York have higher salary thresholds for exempt employees, and those rules still do apply no matter what's happening at the federal level, right? At the federal level. Now, again, that's not for all states because many states follow just the federal rules, but some states, like I said, New York and California have their own things. Okay, so while things are staying put at the federal level for now, make sure you also are watching the state requirements. You might want to take some action depending on what state you're in. And if you have any questions about any of this, don't hesitate to reach out and talk to our team. Okay, all right. So let's shift gears a little bit and talk about the Department of Labor's handling of the independent contractor classification. So because that's been also a little bit of a roller coaster. So again, under the Biden administration, the Department of Labor introduced a brand new rule in 2024, a six-factor test that was supposed to clarify when someone should be considered an employee versus an independent contractor. Now that rule immediately sparked a whole bunch of lawsuits in federal court, and the Department of Labor said, yeah, okay, we might need to rethink some of this. In fact, now they're actually thinking about scraping the whole thing entirely and doing something else. So now we fast forward to May of 2025, just a month ago, and we got some really big news from the Department of Labor. So while the 2024 rule technically still exists on paper, they announced they're not going to enforce it. So they put an official pause on the whole thing, right? They put a pause on the whole thing. So pretty crazy, right? So instead of going back to the older, more familiar, economies reality, test, they basically said, no, we're going to keep it as is, but we're not going to do anything about it, right? We're not going to do anything about it, which is always kind of, very interesting, I think, to me, because it's a way of just kind of, kicking the can down the road. Okay, so just kind of keep this in mind. This is very, very important. If they're going to go back to this economic realities test, there's some factors that you need to look at. Some of the bigger factors is they're going to look at, is the person doing, is the person's job an integral part of the business, right? Is the relationship ongoing, or is this for a short, specific period of time? Have they made their own kind of financial investments in the business? How much control do they have? And so there's these things, are things that you have to be aware of. Now, our advice, because there's so much change happening at the federal level, as we've been talking about, at the state level as well, is that if you're hiring any doctor associates, you should just hire them as employees to avoid these problems in the future, right? Because the reality is that it's nearly impossible to hire a doctor associate as an independent contractor based on all these rule changes that are happening. And if you're risk averse and you don't want to deal with the IRS, you don't want to deal with your state situation, just do that. Now, some of you are hiring your hygienists and RDAs, your opticians, your veterinarian, your techs, your whatever, as independent contractors. And I can tell you there that those folks definitely, definitely do not qualify as independent contractors. The only people that might, in certain limited situations, is a true doctor associate. Okay, and the key takeaway that I want you to have is that there's no single factor, there's no one single factor that decides this whole thing, right? It's an analysis that you need to do, and what's written in a contract doesn't necessarily override what's actually happening in real life, right? So many of you have contracts that say a lot of different things, but in real life they're doing it exactly the opposite, right? They're not bringing in their instruments, they're not paying for stuff, they're not, they don't have the power to fire and hire employees. So just make sure you're being honest with yourself with regard to that. And I'm not a risk averse guy. I don't mind taking risk, personally, and also for our clients. Um, when they're open to it. But I do think there's some things that are more risky than others, and this is one of those that we are seeing more and more become an issue. Okay, so just please keep that in mind. Okay, let's talk a little bit about employee classifications. A little bit more deeply. In terms of who's exempt, non-exempt, a true independent contractor. As most of you know, we've been kind of talking about that just a few minutes ago in terms of behavior control, financial control, the length of the relationship. These are, absolute necessities when you are looking to hire someone. So when you're thinking of an exempt employee, right? When you're thinking of an exempt employee, there's really only you know two people in an office that could truly qualify, in my opinion. The doctor associate that we were just talking about, and then sometimes an office manager, right? An office manager. Now, the office manager has to be paid a salary. Okay, so they cannot be paid hourly or a percentage of production or revenues or whatever. They have to be paid a salary, and then they have to be doing high level duties, right? So that means that they're spending more than 51% of their times managing others, making hiring and firing decisions, and doing it with total autonomy or almost total autonomy. Okay. And so calling someone a manager, just giving them a title, isn't enough, right? Isn't enough. They actually have to be doing those tasks that we've been talking about. And so just kind of keep that in mind. Making sure that your non-exempt staff, I think, are using electronic time clock systems. I think that's hugely important. We obviously have, I think, the best one in the industry at HR for Health, because there's no guessing in terms of how many hours they've worked and things of that nature. Some other general questions that we sometimes get is, if I pay somebody per diem, are they exempt from overtime rules? And the answer is no. You still need to track hours and pay appropriately, even if they are, paid per diem. And if you have someone that works under multiple pay rates during the week, you'll need to calculate overtime using sort of a weighted average model. And in some cases, the higher rate. So again, HR for Health will handle all this for you in the system. And so if you have anybody do it in that category, just make sure that you take that into account. And finally, with regard to compliance, don't forget about bonuses, right? Non-discretionary bonuses like performance or attendance bonuses have to be included as part of overtime. Discretionary bonuses like surprise holiday gifts don't. Okay, so non-discretionary, does, discretionary does not. Okay, so just kind of keep that in mind as you think through bonuses as well. Of course, HR for Health handles these calculations automatically for you, which is a huge relief when you're juggling compliance and patients and payroll and all this kind of stuff. But I think the bottom line is that classification is not just a paperwork detail. Okay, it's a legal risk, and if you're unsure of how to do it, just take a closer look at how the employee functions on a day-to-day basis, not just what you've written in the contract. Okay, so a little bit of clarity now can save you a lot of headaches down the road. And if many of you have independent contractors and you want to switch them to employees, or vice versa, just give us a call and we'll talk to you about how to do it and how to be smart about it. Okay, that was a lot of stuff on the federal level, more than usual, but I wanted to give you guys that detail. Let's move now to the states. Okay, so a lot of things happening at the state level. So a quick reminder for everyone that managing exempt employees, when you're managing, make sure you're checking state minimum salary requirements. Okay, I want to make sure that you know that, and that's what I want to start off talking to you about, because the minimum wage updates are happening across the country, right? Don't just focus on the federal minimum wage, but also check your state minimum wage laws, right? So a lot of folks think that if they're paying their state minimum wage, they're in the clear, but you're not. Some cities, some counties have actually higher thresholds for minimum wage than the state guideline, right? So I did a presentation last night for a really large study group in Los Angeles, and their minimum wage is almost $1 more than the state of California's minimum wage, right? So you just have to kind of know this. It's very, very important. And these higher thresholds for minimum wage are some of them are going into effect on July 1st of 2025. So just in a few days, right? So pretty crazy. And these state-specific wages kick in across several jurisdictions. So it's not just one, but several jurisdictions around the country. So if you've got employees like in San Francisco or Seattle or Denver, you'll want to double check that your payroll reflects the new rates. And remember, failing to do so could land you in some serious wage violation penalties, and those add up really fast. And you know who's not telling you about these? Your payroll company, right? Your payroll companies do not care if you're paying minimum wage or not, right? They will not tell you. We've had a handful of cases already this year where large payroll companies, names that you guys would recognize in a second, have failed to tell their customers, our clients, that they were paying less than minimum wage. I mean, it's crazy to me, right? Your one job, your one job as a payroll company is to make sure that you are running payroll correctly for, for your clients, and you don't even tell them they're paying less than minimum wage. I mean, it is so crazy to me what murderous activities these payroll companies get away with. Don't even get me started about their claims that they do HR when they do not do HR. They just give you a list of documents and that's it. It's not HR compliance. But by not telling you about minimum wage, I mean, I'm just like pulling my hair out, and I don't have a lot left, so it's like even worse for me. But it is crazy to me. It's crazy to me that they're not even doing that very basic thing. So the good news is that if you're using HR for Health, our system automatically tracks and updates these city-specific wage increases for you. That means that your payroll stays accurate, compliant, and stress free, hopefully. So no more Googling required, no more chat GPT, no more spreadsheets, right? It's all done for you. So please keep an eye out on this. Okay. Now let's talk a little bit about uh, transparency laws. All right, this is like a fast growing trend around the country, as you can see from the list of states. So the past couple of years, we've seen a wave of states passing laws that require employers to disclose salary ranges in job postings. Okay, now the momentum isn't slowing down, right? As of 2025, New Jersey, Vermont are some of the latest states to join. And so this club, where states kind of follow each other when rules change, is a serious thing, and they all do it. And as you can see from this list, it's not, oh, it's the states on the coast, or it's, blue states or red states. No, we've got all different kinds of states here. So from Hawaii to Colorado to New Jersey, this isn't just a West Coast thing or a progressive experiment thing. It's quickly becoming the new normal, right? Each state's laws do look a little bit different. So some states require salary ranges when the applicant requests them, while others require it in the job posting itself, right? But the big idea is really the same, which is that employers need to be upfront about what the role pays. Okay. And if you're hiring, this is a trend you just cannot afford to ignore. So make sure that for legal reasons, for your reputation, for retention, for attracting top talent, you're following these rules. And if you have any questions about them, just reach out to our team at HR for Health, and we'll walk you through it. So with these pay transparency laws gaining steam across the country, the big question, I think, is what do you actually need to do to stay compliant? Because, I mean, let's be honest, this isn't just about throwing a number on a job ad, right? There are specific rules that you have to follow, and they vary state by state. So here are the big ones you need to know. Okay, so in some states you need to include a pay range, not just in the public job posting, but internal ones too. Now, whether you're hiring externally or promoting someone from within, most states now require you to list the salary range upfront. Okay. Now, some other states go a step further. They say employees have the right to know the pay range for their current role. So if someone asks, hey, you've got to be ready to share them that information. Okay. Now, you also need to notify current employees about promotion opportunities before you fill that position. No more quietly hiring someone else in a role, that an internal employee may be wanted, right? And so these are things that are happening at the state levels, and every state, like I said, is a little bit different. Okay, so how do you make sure your records are done well and tight? Well, you want to document the job description, right? If any of you, if anybody listening today or any of your friends do not have good job descriptions, just have them reach out to us. We will provide you with job descriptions, really, really strong ones that you can use. Okay. Then you want to track compensation history, right? So that includes, changes that have occurred over time. Okay. Changes that occurred over time. Of course, if you're on HR for Health, this is all tracked for you, but if you want to track that. And then you want to provide a general overview of the benefits and other perks when you're posting the job. And my recommendation is make sure you are making it absolutely clear, like all the things, all the perks that you provide, lunches and breaks, not lunches and breaks, by themselves, of course, because you have to provide that. But if you're going to provide lunch, like you have parties all the time, you have events, you have summer events, winter events, this thing, talk about that, right? Make sure the employees know about all the benefits that you provide. And if this sounds like it's a lot, here's the thing, beyond just a compliance thing, this is a huge opportunity for you to build trust and transparency with your current team. Okay. And if you do it right, it shows that you're serious about fairness and you're serious about pay equity. And if you're using a tool like HR for Health, a lot of this record keeping, a lot of this documentation just happens automatically for you. So there's not as much for you to do, right? Job descriptions, pay histories, promotion notices, all of that is done for you in the system. So you're not scrambling when the laws change and you're already covered. Okay. So from a compliance tip, secret sauce is, you know, um, update your job descriptions, get your templates done, train the individuals who are responsible for posting your job. So your office administrator, your office manager, maybe your spouse, maybe, to include these job descriptions and compensation details and benefits in the posting, right? In the posting. And the HR for Health advantage here, of course, is that you're storing all of this data, all of these things in our system. We've got them for you. We've got promotion policies and all of that. And if you need them, and it reduces your risk. Okay, let's talk about something else. Let's kind of shift gears a little bit. I know we're jumping around, but the laws are jumping around too. Let's talk a little bit about lactation accommodation at work. So as of right now, 30 states have passed laws that require employers to provide lactation accommodation. And New Hampshire is the latest one to join the movement, with its law kicking in on July 1st of 2025. Now, this isn't just about providing a space, it's about creating a safe, clean, private, and accessible location so that the employee can nurse and pump during the workday. Okay. And no, a bathroom does not count. It needs to be, a private office or something of that nature. I will tell you, if you have cameras in your private office, and that's where, you have designated for the lactation accommodation, please make sure you turn off the cameras. Those are big no-nos from a privacy perspective, from a liability perspective, and just kind of discuss things. So make sure if you have cameras in your private office, you're turning all that off. Okay. But most of these laws require you to provide a reasonable break time for pumping, reasonable. So if it's going way too much, or it's happening too often, you can ask the employee to clock out. Make sure you're absolutely clear about the policy, right? What your policy is. Ideally, it'll be in the employment manual, but if it's not, make sure you have another kind of policy for it. And have a system where there's like written procedures for them to request the accommodation. So if they need to, make sure they are putting it in an email or some other communication. And again, this isn't about just compliance, it's also about supporting your working parents and building a workplace where the culture really values health and equity. And the reality is that all of you are medical, dental practices. I mean, at the end of the day, this is what you're all about. And so, even though I know it's a disruption to your business, it's really an important way of communicating what matters to you and what you value to your team. And if you're using HR for Health, these policies, can easily be updated. The breaks can be documented, and organized within our time clock. And so you're always sort of a step ahead when these rules change. But just kind of keep that in mind. There are some tools for you. So in terms of some, pro tips when it comes to, lactation accommodations, make sure you've got a designated private space. Again, not a bathroom. Allow the employees to nurse there comfortably and privately. So there needs to be like power, ideally, somewhere where the door can be locked, an office where the door can be locked. But don't just stop there. You also want to include an accommodation policy, a lactation accommodation policy in both your handbook and maybe some onboarding materials as well. And it's a very small step, but it goes really a long way as far as compliance is concerned. And as I mentioned just a minute ago, it also shows your team that you support them as working parents. And all of this again is super, super easy to track compliance, update your manual and whatnot if you're using HR for Health. Okay, paid sick leave. Paid sick leave is another area where we're seeing steady movement across the country. Are you guys seeing a trend? Right? Are you seeing a trend? This, when laws change in certain states, the other states copy it. Right? Some states might be faster than others, but the laws change across the country almost, predictably. And the reason is because a state takes the initial jump or leap, and then they have some benefits from it. It starts to work well, and then other states start to copy. So in 2025, we've got 4 more states jumping on board with either new or expanded leave requirements. So that's Alaska, Michigan, Minnesota, and Missouri. Okay, that means if you've got employees in any of those states, there are fresh rules you need to follow. So what's changing? Well, more and more states and even individual cities are now requiring employers to provide paid sick leave to employees. That's right, cities. So what that means is that the state may have its own rule, and then the city and sometimes the counties too have their own rules that are sometimes even more stringent than the state rules. So you gotta follow the rule that is the most stringent. Okay. And so this covers illness, preventive care. A lot of times it covers family members as well. So the idea is very simple. Since COVID, the government basically wants employees to not have to choose between their health and a paycheck, which is why, as an employer, you are required to provide paid sick leave. And this isn't, like I mentioned, just a blue state trend anymore, right? It's gaining bipartisan traction, which is why so many states are coming on board, especially since we've learned that during the pandemic, how public health and workplace flexibility can impact our population. And so we're seeing a lot of change as far as this is concerned. So keep up with it, and I think the lesson here is make sure you're compliant and that you are using HR4L to its full capacity. Now, to dig a little bit deeper, with some of these states that have these new sick leave laws, like Alaska, Michigan, Minnesota, and Missouri, it's important to pause and get a sort of a clear idea on some points of confusion that is occurring. Okay, so one is, what is the difference between PTO and a separate sick and vacation policy? So here's really the breakdown. Okay, PTO is a single bank of time that combines vacation, sick leave, and sometimes even personal days. Okay. An employee can use it however they choose, right? However they choose, whether they're sick, going on vacation, or just need a personal day, right? Or just need a personal day. So that's PTO. On the other hand, a separate sick and vacation policy keeps those time blocks or banks, separate, right, and distinct. So sick time is for illness or medical needs, while vacation is, well, for vacation. Now, personally, I prefer in my companies paid time off because I do not like someone lying to me. It destroys my relationship with them the very first time I find them, to find or catch them in a lie. And so I would rather someone tell me, "Hey, I'm going on vacation to, Disneyland," than to say, "Oh man, I'm so sick," and then they spend 3 days in Disneyland and I see pictures or hear about it or whatever, right? That would just like kill me. And so for me personally, paid time off is the way to go. Now, you have to structure it, correctly, because you do have some legal obligations. And there are specific things that you need to do if you do PTO, and you don't do a sick time vacation block. And so you have to be aware of those, state by state, and because there are, different accrual schedules that might apply. There's more different reimbursements that may be, occur. How that time is earned may be different, with a PTO versus, sick and vacation. So just kind of keep these things in mind. If I had to summarize them, I would say, first, how is the time earned, right? If you decide to do PTO, you want to talk about that. Two, what is the accrual schedule if you do an accrual schedule? Okay. Meaning, is it on the calendar year? Is it on their anniversary of their employment? When can they use their time, right? The third, when can they use their time? In some states have waiting periods, right? 30 days, 90 days, whatever. So you got to keep that in mind. Fourth, how is that unused time going to carry over to the next year? Okay, some states have very specific rules about that. And again, if you're going to do PTO, you have to kind of massage some of these, and our team can help you, of course. And then, can you, as an employer, control when the time is used? So some of you, for example, close for 4th of July, the whole week. Can you force your employees to use it, during that week when it's a forced closure, right? Again, we'll see. But finally, I would say, how do you track all of this? Because it does need to be tracked. And this is where HR for Health is a difference maker, because instead of doing things manually or doing it in your practice management software, which is not tracking things correctly, you need a software like HR for Health that is customized to you. So our benefits portion is completely customizable, completely customizable. So if you want somebody to earn, PTO based on the rotation of the moon around, the earth, and the earth around the sun, we can customize all that for you, right? So and I'm saying that, of course, tongue in cheek, but it's very, very customizable compared to any other system, because we built it for you as the doctors, as opposed to, other businesses. And so just make sure you use those. If you haven't already, it will make sure you're compliant both at the state and local level. Okay, all right. So what are some wacky ideas that I sometimes see, around getting around sick leave? Well, there's a couple that I would just say, you have to be, aware of. One is, um, if you call sick leave, uh, and vacation, and you say, look, it's all vacation, we don't do sick leave here, then that doesn't really fly, because these are state laws that have been passed. So you're mandated to provide paid sick leave if you're in a state that provides it. You can't couch it as just vacation. You have to keep it as either sick leave, paid sick leave, or you call it PTO. okay, or you call it PTO. So that's very important. Some other examples are I've seen people say, you know what, I'm just going to pay out, you know, paid sick leave on the first day of their anniversary or on the first day of their job when they start working for me, so I don't have to deal with it, you know, later in the year. And you know that does create some problems, of course, and a lot of states don't allow that, first of all. But you have to remember what the objective was of creating sick leave, right? The objective of creating sick leave was so that employees could use it in during the year when they're sick, so they don't have to pick between being sick and coming to work or a paycheck. So if you pay it all up front, even though you're sort of moving it up, in many states that goes against sort of what their goal was for passing sick leave. So it might be against those rules. Okay. So what can you do? What does fly? Well, you should definitely have a written sick leave policy, absolutely, in your manual and other places. Make sure you document in real time how much time is available. Some states require you to put this on their paychecks. Some states allow you to not put it on the paychecks, but have a system that allows them to see it, like HR for Health, in real time. So that's very important. And so just kind of keep that in mind, because it doesn't have to be on the wage statement. It can be on the platform. And a lot of times it's better for it to be. And then remember to keep those records for at least 3 to 4 years, right? Keep those records for 3 to 4 years. So just remember that. And in almost every state, unused sick time isn't paid out when someone leaves, right? So remember that. So unused sick time is not paid out when someone leaves, although PTO is, right? PTO is, because it's treated the same as vacation in most states. Okay. Now, for those of you that love webinars, we are doing a webinar specifically diving into these PTO questions. It's on July 18th. It's titled the mid-year PTO update and what's changed. And so be on the lookout for those emails, or if you have your phone now, you can scan this QR code and it'll take you to the registration page. It's free. All you have to do is just put in your email and some other information potentially, and then you will get notified about that. This is a really, really good presentation. And lucky for you, I'm not the one doing it, so you'll get to hear someone else's voice. But yes, really important. So if you have your phone, go ahead and do this. If you're listening to us on your phone and you can't take a picture of this, put a message into the chat, or maybe Jasmine will put a link for you guys there so you can do it later. Okay. All right, as we end, I want to just go back to the basics, because the basics of HR compliance is still something that we see a lot, and still be problematic in many offices. Okay, so one of the basics, of course, is all the required documents that you need to have. Every state is a little bit different, but it's anywhere from 10, 12, 15, on the low end, to 27 plus on the high end. So there's just a lot of variance, and you just need to have all of these documents. And if you remember my earlier example with my daughter, right? This was a national paychecks company, right? A national paychecks company. And their HR platform that this nonprofit was using had left out the I-9, right? The immigration document. It wasn't there. It wasn't there. I mean, how nonsensical is that, right? And so, you just have to remember that these kinds of things happen, when people are not doing HR compliance, they're doing payroll, but they give you documents, right? We are doing HR compliance, but we also have payroll, right? We also have payroll with Gusto embedded, which, by the way, if you were on our old system of payroll, I am sorry. It was a terrible system and a terrible experience for many of you. And this is one of the reasons why we've moved to Gusto. We are excited by it because it's fully embedded in our system now. You don't have to talk to any humans. It's all automated. You can run payroll in minutes, and it's with the Gusto platform on the back end. So it is super, super, super powerful. and it's cheaper than even gusto.com. So don't tell them I said that, but it's wonderful. So you guys are way ahead. But make sure you have these policies, these required documents, the I-9, the immigration document, the W-4. Some states have their own version. The sexual harassment information sheet. We've kind of forgotten about the Me Too movement since COVID, but sexual harassment is still a thing in the workplace. So make sure you give them that, and then a whole lot of other documents as well. Next thing is the employment handbook. Please, update it. Make sure you get a new one every year. If you're an HR for Health customer, you don't have to worry about it, of course, because you get a new one no matter what every year. Just make sure you do that. Please do not chat GPT this stuff. Do not do anything like that. You will not get something that is compliant and right for you. Okay, it just doesn't work. There's a lot of great things about ChatGPT, but this is not one of them, right? This is not one of them. It just cannot handle what you need for your practice at this point. In 5 years, 7 years, something, I think it might be a different story. Okay, make sure your documents are totally, maintained in a safe place. If you're still doing things on paper, please move them electronically. Either scan them onto some platform or put them onto HR for Health so that they can never be destroyed or ruined or anything of that nature. Doing performance reviews, I think at least once a year is great. If you hire a new employee, we recommend you do a mini review at 30, 60, and 90 days as well, just in the beginning. And if you need any coaching on how to do this, please let us know. Any leaves of absences for medical or other reasons, document that. If they need accommodations, make sure that's all done as well. And of course, payroll and tax compliance, make sure it is done properly. If your CPA is doing your payroll, please be very careful. They sometimes use, a lot of times they use these third-party providers, and things kind of go wrong. We do a lot of practice sales at the law firm, as many of you know, and I can't tell you how many times we find out that there's a employment tax lien on a practice that our client is buying because the employment taxes weren't paid properly by the payroll company, and a lot of times it's done by the CPAs and others. And so just be very, very careful about that. Okay, so timekeeping, of course, you want to make sure that everyone is clocking in and out of the office. Even if you think someone is exempt, from that, just please make sure that you have them clock in and clock out. It's always a safe thing to do. Many of you won't have your doctor associates clock in and clock out, and I can understand why, because they're professionals and whatnot. But please make sure everyone else in your office does. Try not to round up or round down in terms of time clocks. There are some time clocks out there and some practice management systems that do round up and round down. And in both situations, it's bad. If it rounds up, you're paying more than you should. If it rounds down, you're not paying enough, and then you could get sued. So just like, it's terrible in both situations. And so make sure you're doing that. And we've gotten a lot of questions about, can I have a system that automatically clocks out my employees, if it's lunchtime and things of that nature? And that's not allowed, right? That's not allowed. You can't just clock out an employee because it hits 12 o'clock if they're working. If they're working, they need to keep getting paid, and so they need to clock out themselves, right? So very, very important for that. And so yeah, so just kind of keep these things in mind when it comes to timekeeping. Hugely important. So as we end, what I would tell you is that I know this is a lot. I know we went through a lot. I mentioned it early on. This wasn't meant to make you, HR experts, but to give you enough information so that you can raise your hand and ask for help. Because if you saw your state's name there, you know that there are laws changing in your state, so it's time to take action. if you are in a neighboring state of one of those states, then you should expect that those laws will absolutely change in the future. So it's a great idea to get compliant now, as opposed to waiting until the laws change, because then it might be too late. It might be too late, and you'll be on the back foot. And the last thing I would say about HR compliance, I think I want you to know that our goal, at HR for Health, the reason why I started this company almost 12 years ago now, um, is on a very simple, premise, which is that our goal is to prevent you from having to deal with these pitfalls, from arising when you are coming into the office and doing your best for patients, and you're trying to do good by them, and yet you just don't have the time and the energy to worry about these HR issues. And when before we started HR for Health, you know, the reason we wanted to do this was because so many of our clients at the law firm were getting sued by their employees, and there was no solution out there that truly served you. And I don't want to get emotional about it, but I mean, this is why we did this, right? And when I hear these stories of doctors still getting sued, by because they haven't taken these basic steps of being HR compliant, it really pains me, because I know how hard you work. I know how hard my wife works. I know my sister, how hard she worked before she got disabled and couldn't practice anymore. I mean, there's just, you work so hard and you put so much time into it for yourself, for your patients, for your team, for your own families, and to get in a position where you're paying money to lawyers, because that's really what it's about, paying money to these lawyers who are suing you. It just is painful. So I urge you to get HR compliant. Fix your house with regard to what HR is concerned. If you're already a customer, please use our HR advising. They're there to take your case, one by one. They spend a lot of time with you. Be patient with them. They're wonderful people trying to do good. And so they will protect you as much as they can. If they can't, they'll refer you to me or somebody else, who can help you from a legal perspective. And then make sure you get your employment handbook updated. And if you do these things, your chance of getting in these wage and hour cases will fall dramatically, dramatically. And if you do still get sued, we can win so many of these cases or reduce the penalties to nearly zero, because you've done so many things right, right? And that's the battle. My goal is for you to never get sued, but if you do, then at least you have all this documentation to protect you. All right. Well, I want to thank you guys.
Oh,
And if you have
there's
any.
a couple questions for you, Ali, in the chat, just on
Yeah,
the
yeah,
right.
yeah, absolutely. Yeah, I'll jump on those in a second. But what I was going to say is, I want to thank you all for being here. I want you to have a incredible weekend, and make sure that, if you have any questions about any of the stuff we talked about today, please make sure you reach out to our team. All right. Okay. Now let's talk. Let me go through some of these questions. Actually, Jasmine, I don't think I am seeing the anything
Ooh,
in the Q&A. Do
move
you?
to the little question icon in the middle rather than the chat bar. I can read it out
Oh,
for you if you'd like, though.
okay, hold on. Let me see if I can see it first. It might be easier if I do it. Hold on, let me see. You said the chat bar? Okay.
The little question
Oh, question
icon in the
mark. Oh,
top
I see
right.
it. Oh, I'm sorry. Okay, got it, got it, got it. Here it is. Okay, so let's see here.
And you can click in to open it up.
Okay, yeah, I see it open. I see no questions though. Okay, why don't you read the questions?
Okay, so here's first one from Shital. The question is, so is the incorporation county the deciding factor for minimum wage determination, or is it their physical workplace?
Ah, very good question. So the question is the county that you're incorporated in, the county that matters, or where the office is? And the answer is, it's where the office is located. It's the place of business. That's where the minimum wage applies. Now, if you have a corporate office, let's say you have a group practice and you have many of the locations. If you have a location in a different county, then that county's rules would apply. But it's where the office is located.
Awesome. Okay. And then next one. So to confirm, replacing sick leave as PTO has the intangible benefit of reducing lying, which we have to weigh against the tangible cost of creating a liability we have to pay out when the employee leaves, i.e., PTO must be paid out, but sick doesn't. Are there any other major considerations to combining sick leave and PTO?
I don't know who wrote that question, but whoever wrote that question, that was the most eloquently said question I think I've ever heard. So that was very well written. Yes, that is the major. That's the main issue with merging vacation and sick leave into PTO. But there are some other ones as well, like for example, accrual. You got to make sure that PTO is accrued at the same level as paid sick leave. And so there's that. And then some states also have different rules regarding what happens with PTO in terms of rollover into the following year. So those would be the major changes. But in the grand scheme of things, the difference between the two cost wise is not huge. It's not huge. But if you have questions about it, we can run some different scenarios.
Nice. And then here's one from Spencer. Sorry, I just wanted more clarification on when it is permissible to request a doctor's note for sick time off.
Yeah, great question. So again, some states vary on this, but the general rule is that uh, while they are using their sick time, so let's say you're in a state that allows for 5 days of paid sick leave. In some states, you're not allowed to act to doctors. You're not allowed to ask for a doctor's note during those 5 days that they have sick time. If they need a sixth day, for example, or a seventh day beyond paid sick leave, then you can ask for a doctor's note for that additional time. So again, no doctor's notes or anything during the sick the paid sick time, but if they go beyond it, then you can ask for doctor's notes. Yeah, good question.
Nice. And then here's one that was asked that I had an answer for in the chat. So, does the software even track tardy and present data of how many times they were tardy? So the answer is yes, our software does track tardies in real time based on their schedule shifts. So these will automatically track and create a tardy for each instance that you can then leave notes on and mark them as excused or unexcused lateness. We also automatically track no-shows. So if your team doesn't show up for a shift, you can set it and forget it for all of your attendance related issues, as well as filter by date range for tardies. So you can see specific data on like general time periods.
Yeah, very well said, Jasmine. And here's what I'll tell to the person who also asked that question is this. When we've done some analysis, when we look at the performance of employees, tardiness is the number one marker for an effective employee. In other words, if there's an employee who is tardy frequently, their performance level falls greatly. And it makes sense when you think about it, right? It goes to their psychology. Right? Are they on time? Do they care about the job? Are they coming to the morning huddle? All these things impact how they are in the office, and it's one of the reasons we created the tardiness tracker. And when you run the percentages, it's great to have that data when you're sitting to do the annual performance reviews, because you can show them how often they've been tardy, and that allows for a really great conversation.
Yeah, and that is all of the questions. Oh, wait, 1 minute. One more.
All right.
Last one from Yael. So if someone requests vacation pay for the day, but you found out they went to Disney, you still have to pay them?
Vacation, yes, yes, because they can use their vacation, however they want. So that's exactly right.
I think, did you mean maybe she meant sick leave? Ah, she did. Yeah, she sent another one. If someone requests sick pay, but you find out they were on vacation.
Yeah, so In theory, most states allow you to not pay them for that if it's not truly for sick leave. If it's not truly for like a medical reason. But what I would do instead is I would go ahead and pay them for it so that you don't run afoul of the wage and hour rules, right? The compensation rules. And then I would write them up for basically lying to you, and handle it as that. So because that's what they've done, right? And then you can use it as a learning opportunity for the employees so they realize that what you care about and what you value. So I wouldn't not pay them because that opens up different problems. So I would go ahead and do that, even though some states allow you to not pay them. But then I would write them up and then handle it that way. And if it happens again, then I would let them.
Okay, I think,
Wonderful.
oh, one minute. One more from Emma. Can you please clarify the meal penalty rules when it is required to pay?
Okay, so it depends on what state you're in, but when if you do not provide a meal break to the employees, and let's say you're in a state that requires you to provide 30 minutes of lunch, during between the fourth and the sixth hours of the day, which is very typical. If you're in that category, if you don't provide it, then by the next payroll, you have to pay them 1 hour's worth of their wage as penalty on their next paycheck. And so that's how that works. The question then is, well, did you provide it? Did you not provide it? Did they have to take it? Did they not have to take it? All those things depend on kind of your state. And so if you have questions about that, please reach out to us at HR for Health and we'll walk you through exactly how to handle those scenarios, because again, it's very state specific. But to answer your question, the meal break violation would have to be paid on the next payroll.
Awesome. Okay.
Awesome.
And then just a final note for everyone, there are some additional law updates that, they were a little bit too specific to individual states, so we didn't include in the full presentation. You will be receiving our full law updates guide at the end of the webinar, along with a recording and the slide deck. So there will be some more state-specific information in there as well. So once you receive that, if you do have specific questions, do reach out to our team. There'll be yes, you will have we will give you the recording to be able to watch it again. Yes, Diane. So yeah, that's Ali, if you want to just close off, that's about it.
Thanks, Jasmine. Thanks, everyone. Have a wonderful weekend.
Thanks, guys.